Hello everyone, this is your host Urvashi Chauhan. Welcome back to another episode of Courts Today by Livelaw, your one-step destination to all legal developments in the country. Let us start. Starting with an important update, the Patna High Court today set aside the Bihar Reservation for Scheduled Castes, Scheduled Tribes and Other Backward Classes Amendment Act of 2023 and the Bihar In Admission in Educational Institutions Reservation Amendment Act of 2023. The division bench of Chief Justice K. Vinod Chandran and Justice Harish Kumar were considering a public interest litigation which challenged the amendment passed by the Bihar legislature to increase the reservation for backward classes, extremely backward classes, scheduled castes and scheduled tribes from the existing 50% to 65%. The High Court has set aside the amendments as ultra-vires and being violative of equality under the Indian Constitution. Following the caste-based survey report, the government of Chief Minister Nitish Kumar last year issued gazette notifications for raising the quota of the deprived castes. Next is an update on the NEET undergraduate 2024 exam results controversy. The Supreme Court today stayed proceedings in petitions filed in the Rajasthan, Calcutta and Bombay High Courts regarding the alleged paper leak in the NEET undergraduate exam which was held on 5th May this year. A vacation bench of Justices Vikram Nath and S.V.N. Bhatti passed the order while issuing notice on a transfer petition filed by the National Testing Agency. The NTA is seeking the transfer of these petitions from the High Court to the Supreme Court. Last week, the Supreme Court had issued on NTA's petition to transfer a similar petition pending in the Delhi High Court. Today, the court also issued notice on certain other writ petitions alleging discrepancies in the conduct of NEET-UG and tagged them with connected matters which are posted on 8th of July. The court reiterated that it was not staying the counselling process and orally said that it is understood that the admission process will be subject to the result of the petitions. The court has also refused to stay the retest scheduled on 23rd June for 1,563 candidates who were granted grace marks in the NEET undergraduate 2024 exam. After revoking the controversial decision to award grace marks to these candidates, the National Testing Agency gave an option of a retest to them. Challenging the decision, a writ petition was filed in the Supreme Court. While the bench agreed to issue notice on this petition, it refused to stay the retest. Coming to an update on the Delhi liquor policy case. A Delhi court today reserved order on the bail plea of Chief Minister Arvind Kejriwal in the money laundering case connected to the alleged liquor policy scam. Vacation Judge Nyay Bindu of Rouse Avenue Courts reserved the order after Additional Solicitor General S.V. Raju, appearing for the Enforcement Directorate, concluded submissions on behalf of the probe agency. Kejriwal's counsel had concluded his arguments yesterday and presented the rejoinder arguments today. During the hearing, let me tell you, the ASG stated that co-accused Charanpreet Singh received large sums of cash from entrepreneurs and paid for Arvind Kejriwal's hotel stays. He emphasized that the ED had solid evidence in the case and was not investigating baselessly. Raju also mentioned that an adverse inference should be drawn from Kejriwal's refusal to share his mobile phone password. Additionally, the Additional Solicitor General pointed out that the co-accused Vijay Nair, who had no official role in the government or the excise policy, acted as a middleman for Kejriwal. He claimed that Nair's close relationship with the Chief Minister is well established. Rebutting the claims, senior advocate Vikram Chaudhary, representing Kejriwal, argued that Manish Sisodia's bail was rejected by the Supreme Court because he was seeking bail in two separate cases, a scheduled case and the PMLA case. Chaudhary emphasized that currently Kejriwal is not an accused in the CBI case and has been called as a witness instead. He questioned why Kejriwal was not arrested earlier, asking if the ED was acting independently or under some political influence. Additionally, he stated that co-accused Charanpreet Singh never claimed to have paid for Aam Aadmi Party Goa elections or collected proceeds of crime. He also argued that just because Vijay Nair was staying in Minister Kailash Gehlot's house, it does not necessarily indicate a close connection between Nair and Kejriwal. Stay tuned with us to know the verdict in this case. The Supreme Court has posted to 24th June the pleas filed by Haryana Staff Selection Commission against setting aside of a 2022 notification which granted 5% additional marks to domiciles of Haryana in recruitment to certain posts based on socio-economic criteria. The vacation bench of Justices Vikram Nath and S.V.N. Bhatti was dealing with Haryana SSC's challenge to a judgment passed by the Punjab and Haryana High Court on 31st May, which set aside the notification that awarded additional marks to Haryana domiciles for Group C and D posts under socio-economic criteria. This included conditions like family income below 1.80 lakh rupees, specific familial circumstances, and belonging to denotified or nomadic tribes of Haryana. The court observed that the criteria favored only those with Haryana domicile and residence. Commenting that rules ought to be framed based upon actual data and not political agendas, the High Court held the grant of bonus marks in Common Entrance Test Results 2023 to be violative of Articles 14, 15 and 16 of the Constitution of India and held that fresh selection process be carried out. Aggrieved by the High Court's judgment, Haryana SSC and others have approached the top court. The matter will now be taken up coming Monday. Stay tuned. The Calcutta High Court today declined a plea by Leader of Opposition and BJP leader Suvendu Adhikari to hold a protest meeting outside Raj Bhavan over alleged instances of post-poll violence which have taken place in the state of West Bengal. Adhikari's counsel submitted that he wished to hold a 4-day-long dharna along with those affected by the alleged post-poll violence in the aftermath of the recently concluded Lok Sabha elections outside the main gate of the Raj Bhavan. It was argued that the Kolkata police authorities had declined permission for the same, leading to the present writ petition. Let me tell you, Adhikari had also moved a public interest litigation highlighting alleged incidents of post-poll violence in West Bengal, leading to the High Court extending the stay of central forces in the state. At the present hearing, Adhikari's counsel argued that the police had earlier allowed the ruling TMC government to hold a rally outside the Raj Bhavan gates, and hence the law must be equally applied to all political parties. The Advocate General for the state submitted that the application sent to the police asking for permission was unsustainable since the BJP was seeking to hold their protest at the same venue as the TMC did in the past, and that the police had rejected their request due to administrative concerns. Upon hearing both sides, a single bench of Justice Amrita Sinha directed Adhikari's counsel to come up with alternative protest sites while rejecting their request. And now let me tell you, a Bengaluru court has restrained the media from printing, publishing or telecasting the news or any other defamatory statement against Vijayalakshmi Darshan, her husband Darshan and her family members. Additional City Civil and Sessions Judge passed the ex parte temporary injunction order on the suit filed by Vijayalakshmi. Her husband, Kannada actor Darshan Srinivas, has been arrested in a murder case. She has argued that the publications and telecasts made so far are not only with regard to the details of the investigation conducted by the police, but also their family relationship. That fabricated news show in the media that the couple are heading towards separation and do not have a healthy relationship. She states that such uncorroborated statements have deeply impacted her family bonding with her husband and also their son. On going through the plaint and averments, the court stated that the family relationship of the plaintiff and her husband are personal matters of the plaintiff and her husband, and therefore the media cannot debate on that and make defamatory statements. Passing the temporary injunction order, the court said that in guise of exposing the offences, the personal life, liberty and reputation of a person cannot be ruined. The Madras High Court has remarked that lawyers also perform public service similar to that of public servants, and thus the government should make sure that funds are allocated for advocates' welfare schemes in a stipulated period. The bench of Justice S.M. Subramaniam and Justice C. Kumarappan was hearing the petition for implementation and enforcement of the Advocates' Welfare Fund Act of 2001 to the Puducherry Union. The court was previously informed that around 200 applications were pending for benefits under the Tamil Nadu Advocates Welfare Fund. Advocate General P.S. Raman informed the court that the state was yet to release an amount of 10 crore for the Advocates Welfare Fund for the year 2022-2023. The court pointed out that the government was in the habit of disbursing funds immediately for other departments, which even went to 60 to 70 lakhs or even 1 crore. The court added that lawyers were also performing a public service and the government could not deny them funds. The Advocate General has assured the court that he would communicate with the concerned department and make sure that the funds are disbursed. If you wish to know more details about the cases I mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Live Law. Do not forget to like, share and subscribe and support us. You can also support us by donating through the thanks button at the bottom of our videos or consider becoming a member at just 89 rupees per month.